Hi, thank you. I think we'll make a start again. We've got the two main topics to cover now over the next half an hour. Topic 3 is witnesses, and the final topic is a bit of a free-for-all. It's titled Where to From Here. Sam will kick off with witnesses.
The first aspect of witnesses that we want to cover is experts. Now, I drew breath heavily because it's a massive, massive topic, and of course the bar runs whole day seminars about expert evidence. I think what we're going to do this morning is simply talk about opinions and when an expert is needed to express one. When you have an opinion that requires an expert, it diverts you down a complex and formal process which must be done correctly, otherwise critical evidence may be inadmissible. So if you're in any doubt as to whether an expert is needed on a topic, it's very important to stop and calmly analyse the evidence you're seeking and the role that your expert can play in adducing that evidence. It can save you from the disaster of having that expert's evidence ruled inadmissible down the track. And this is perhaps more important now in circumstances where the Commissioner is taking a pragmatic approach to the resolution of cases. There are cases in which an expert's report has been found inadmissible because it was prepared by the expert at a time before the expert had signed to acknowledge having read and understood the duties in the Federal Court's practice note as to expert witnesses. The expert must ensure that you must ensure that your expert is properly briefed, including with that practice note and giving the acknowledgement of having read and understood the duties in the practice note if you are to rely on their report later in court. And that's a key point of distinction with the AAT, which recently decided that it was entitled to receive opinion evidence from an expert who hadn't complied with the AAT's own practice statement concerning the form of expert evidence. The other major matter affecting the engagement of an expert is the fact that once the expert's report is relied on in court, privilege is waived in all of the communications between solicitor and expert, and that means that those communications are prepared with an eye to the use that a cross-examiner might make of them. Well, the opinion rule, which is section 76, subsection 1 of the Evidence Act, renders evidence of an opinion inadmissible to prove the existence of a fact about the existence of which the opinion was expressed. And opinion isn't defined in the Evidence Act. It's really an inference drawn from other observable data or facts. Firstly, it's important to remember that evidence can be evidence of a technical nature and not constitute an opinion. For instance, it's helpful to remember in tax cases that an accountant is entitled to give a summary of the financial records of a company, and this isn't a matter of opinion. It's a very helpful tool in a tax case for an accountant to do that. It's certainly preferable to counsel attempting to do it from the bar table in closing submissions. Well, the classic example of an opinion in a tax case is, of course, evaluation, but there are various examples of expert evidence in tax cases going to the establishment of other matters. So, for example, the proof of what's sometimes called the counterfactual in a Part 4A case. There have been 2 cases, at least, that I've been able to find in which an expert was used to establish what the position of various companies in a group or the taxpayer would have been had the taxpayer not entered into or carried out a scheme. the Commissioner said Part 4A applied to. They are Spaskett and Futurus. But what about expert evidence concerning issues of construction? In Ashwick, a 2008 case, there was an issue whether a deduction was available for debt written off as bad, and the debt could be written off, sorry, the deduction was available if the debt was written off in respect of money lent in the ordinary course of a business lending money. And the Commissioner sought to lead some expert evidence about the use of finance entities in corporate groups. The court found that the expert evidence there was not relevant to the question whether money was lent in the ordinary course of carrying out a business of lending. Expert evidence can assist in establishing the accepted meaning of technical terms because the ordinary meaning of a word in a statute is a question of fact. But expert evidence is not receivable as to the meaning of a technical legal term, which is a question of law. And a good example of this, it was the case of Allstate, in which Justice Lindgren considered an application to have an expert prove the content of foreign law and then express a view about the application of that foreign law to the facts of the case. And the party seeking to adduce that evidence relied on Section 80, which is on the slide, which purports to abolish the ultimate issue rule. Justice Lindgren decided that, notwithstanding Section 80, evidence of the expert wasn't admissible to prove the way the foreign law would apply to the facts of the case. His Honour said, application of the law to the facts is the exclusive province of the court, and that's the case despite Section 80, subparagraph A. In Woodside Energy, there was another attempt to use an expert to assist the court in the construction of legislation. That case concerned the petroleum resource rent tax, and the taxpayer in that case sought to adduce evidence from Professor Ross Garnaut, who had been the architect of the petroleum resource rent tax. Professor Garnaut's report went to the concept of an economic rent, which was meant to be a kind of pure profit distinct from accounting profit or taxable income. And the Commissioner objected on grounds, including the ground that this evidence just went to the ultimate issue. In that case, the deduction that the taxpayer sought to have upheld was hedging costs in relation to petroleum. His Honour, Justice French, had to determine whether there was a connection between the claimed expenses and the sale of petroleum products, and the connecting words in relation to were used, and His Honour found that the evidence of Professor Garnaut and another accounting expert could potentially be relevant to the construction of those words in the PRRT Act, and the evidence was, the objection was not upheld. Finally, it's helpful to recall that although construction of a taxing statute and the application of the statute to the facts is, of course, the correct judicial approach to determining liability to tax, accounting evidence can be relevant in the, that is, accounting practices or the accounting treatment of items of income and expenditure can be found to be relevant to the construction of taxing provisions. So in BHP Billiton, a 2002 case involving that company, a majority of the full court endorsed the view that evidence of accounting and business practice will not always be irrelevant in determining when income is earned or ascertaining expenditure.
I would like to cover two rules. The first is Brown and Dunn, and the other is Jones and Dunkel. No doubt very familiar to you all. The rule in Brown and Dunn, just as a quick refresher, is that if a witness is not cross-examined on a point, the other side may be taken to accept it and may not be permitted to ask the court not to accept it. In the context of a tax dispute, the New South Wales Supreme Court has explained the rule as follows. It is necessary to put to an opponent's witness in cross-examination the nature of the case upon which it is proposed to rely on in contradiction of his evidence, particularly where the case relies upon inferences to be drawn from other evidence in the proceedings, unless notice has already clearly been given of the cross-examiner's intention to rely on such matters. Now, the rule is a rule of practice which is designed to give the witness an opportunity to deal with that other evidence or the inferences to be drawn from it, and to allow the other party the opportunity to call evidence to corroborate that explanation or to contradict the inference that's sought to be drawn. The rule is one for fairness, giving the other side that opportunity to deal with the allegations. However, the requirements may be satisfied prior to a hearing, and this is what the Federal Court has said. If you provide to the other side the case which you propose to make in reliance on the documents to which the other side has access and of the inferences you propose to draw from them. A failure to observe the rule in Brown and Dunn does not mean that where the evidence of a witness is not the subject of cross-examination, and where evidence is led in contradiction of that evidence, that the court is required to accept the former evidence. It's a matter of weight that the court will take into account. And the consequences of a failure to observe the rule will depend on the nature and course of the proceedings and the evidence as a whole. And this was a case in the New South Wales Supreme Court. Moving on to Jones and Dunkel, that relates to where if documents that are filed in a proceeding has thrown up issues of facts that the taxpayer is required to explain or contradict, and recalling, of course, that the taxpayer bears the burden. If there are witnesses that the taxpayer can call but does not call, so for example, management or staff, the Commissioner can raise a Jones and Dunkel point, asking the court to infer that the evidence will not assist the taxpayer's case. An example of this was in Transurban. This was a 2004 case, and at first instance, the Commissioner contended that certain fees were akin to profit share or dividends, whereas the taxpayer contended that they were costs or outgoings incurred in deriving its assessable income. The Commissioner put Transurban on notice about a Jones and Dunkel contention. There were current employees of Transurban that they could have called but didn't call, and on that basis the court did draw an inference that the evidence would not have assisted Transurban's case. Now, as you'd be aware, Transurban was subsequently overturned on appeal, but it wasn't on this point. And the Jones and Dunkel rule has also applied in the tribunal. An example of that is in a matter called the Optimiser Group in 2010.
Any particular questions on those topics? I think the significance of Brown and Dunn will never go away. It always crops up occasionally. And Jones and Dunkel's significance is a little bit overrated. The inference is no more than the evidence of a particular witness wouldn't assist. Now, in 90% of cases, the reason why the evidence of a particular witness doesn't assist is because the witness doesn't know anything. So, the court doesn't get very far with a conclusion that the evidence doesn't assist. But they're there. I was going to say their significance is a little bit less now, again, because, at least in the federal court sphere, by the time you get to court, the issues are well and truly engaged, or at least should be, so that these rules, I think, were by and large fair, particularly with Brown and Dunn, fairness rules. And the occasion for ambush should not now arise under the present litigation. However, Brown and Dunn and Jones and Dunkeld have been around for a long, long time, and they'll continue to be around. So we'll move on to the last topic, which is, as I said, headed where to from here. I think, Angela, you're starting first?
Yep. So I guess what we're trying to do in this under this topic is just to have a look at what we've discussed and sort of bring it back all together in the current context. And an obvious feature of the current context is that we have a new commissioner. What I've seen since the appointment of the new commissioner is that a lot of matters are being settled rather than litigated. And what this means on the evidentiary front is that whereas the work was previously done in relation to evidence, so collecting and presenting the evidence was done much closer to the footsteps of court, like much more at the back end of the process. Now there's the opportunity and probably the requirement, the need to bring it up front, including even during audits, objection, ADR. A lot of it can be very useful up front in terms of saving costs and managing risks. Now, I say that because, and that's something Sam's going to explore shortly, but in respect of creating and maintaining relevant records about commercial objectives for why certain transactions are taking place. Often transactions don't take place for tax purposes. They occur because of business and other reasons. If there's proper evidentiary records that are kept, they serve as a form of insurance, because if the Commissioner does want to look into the situation a bit later on, you've got those documents ready to go. You can just click send, go over there, and it could, I think, in some cases completely get rid of a dispute, and in other cases significantly reduce the number of issues that are in disputes, especially on the factual fronts. And so what it can do is not only narrow down what's in dispute and the risk, but also speed up the process. And so the amount of time that the Commissioner may need to spend auditing or working with the company staff, etc., could be reduced and just get to the resolution much quicker. There's certainly been cases I've been involved in where the audit took place more than 10 years ago and you're still trying to fight it out now. And in those cases, what I find it's very, very difficult, more and more difficult to get the evidence because key personnel may have moved on, or the records are not kept anymore because it's been 10, 15, 20 years. So certainly moving that focus to the front end, developing proper records and having that evidence available and being able to enter into that dialogue sooner and providing the Commissioner with information that he does need and would be entitled to obtain anyway, could certainly reduce the amount of time and cost spent on disputes.
There isn't very much I'd want to add to that other than to say, well, it's a little bit like the way international spying was described during the Cold War. It was the art of making sure that incidents didn't occur and holding and retaining records of transactions that may have material tax consequences is a little bit like that, it occurs to me. The tax function in significant taxpayers would always want to have an eye to ensuring that they retain appropriate records of the commercial rationale for transactions and the detail and features of those transactions in order to be in a position to explain them if the Commissioner came knocking. That's it.
I want to throw it open for general questions on this whole topic of evidence. Just something that occurred to me, at least from the particular part that I play in taxation litigation. The nature of the disputes these days is encouraging the use of experts much more, and the use of experts is an area where the Commissioner can involve himself in the fight. In contradistinction to a tax dispute that turns upon simply the facts that occurred at the relevant time, and usually it's the taxpayer who knows what those facts were, and they were either existed or they didn't exist. There's not much that the Commissioner can actively litigate about that other than testing the evidence through some questions and having a look at documents. With expert evidence, it's quite different. It's a new battlefield. We have, the recent case up in Sydney of the Chevron case, there were something like, there was a minimum of 12 economic experts, each of whom I think was an overseas person, and each of whom, that's what they did. They run businesses of consulting for people who need experts to come along and proffer an opinion. So there were 6 on each side. It's a nightmare for people like me. Much happier with some documents and somebody who gets on the witness box and said this is what happened. But the nature of the dispute is causing that, so both taxpayers' representatives and the Commissioner's representatives now need to be much more actively involved in building up a group of experts they can speak with, communicate with, understand at a working level. Justice French in Woodside allowed Professor Garneau to get into the witness box and give his opinion about what he meant when he encouraged the Labor government to introduce the Petroleum Resources Rent Tax Act. It's extraordinary stuff. Imagine trying to cross-examine Professor Garneau. It's tough here, tough at the coalface. Whereas that's at one extreme, and of course there's the other extreme that Michael was referring to with default assessments. Takes me back to the being down in the AAT where there are no records. All the money, of course, has been given by relatives from overseas. That's tough too, I must admit. All right, well, I'm not sure that I added much of practical advice in all of that. Are there any questions? No, well, it's 2:15, we're finished on time. Can I say thank you very much to Angela and Sam?